Appeal number 104, Makinen versus the City of New York.
Good afternoon, Your Honors. My name is Kathy Park. I represent the defendant. I'd like to request 2 minutes for rebuttal.
You may have 2 minutes.
The only reasonable interpretation of the city human rights law is that it forecloses a plaintiff from bringing a disability discrimination claim based purely on a mistaken perception of ongoing alcoholism.
But what would be the purpose of that? Why would they do that?
Well, twofold. First, if you understand what the City Council intended to accomplish specifically with Section 8107A, which is the foundation for plaintiff's claim, that's the provision that bars discrimination based on an actual or perceived disability. What that provision or what that language accomplishes is that it identifies the discriminatory motivations that are prohibited under the statute, and it ensures that even if a defendant is factually mistaken about his or her perception, if that defendant holds or harbors that motivation that is prohibited under the statute, then that is actionable discrimination. Here, the motivation that defendants or that plaintiffs are claiming that defendants held is that it was just merely based on a mistaken perception of alcoholism. And that's not a motivation that's forbidden under the city human rights law. It's not considered discrimination.
It seems to be an administrative determination that may have been made, arguably strongly, that it was incorrect. That being the case, why wouldn't you challenge the determination through an Article 78 rather than say a person who is not disabled is disabled in essence and seek for damages and a determination that the allegation of calling someone disabled is damage worthy in and of itself? So in other words, why not an Article 78? Because that's normally how you challenge this.
Certainly, we agree that an Article 78 would have been an appropriate vehicle for plaintiffs to pursue here, and that would have been their mechanism for challenging the mistaken diagnosis and just completely and challenging that determination. They haven't done that here, and instead, what they're doing is they're litigating a dispute over simply their mistaken diagnosis in the form of a discrimination claim. And as the city,
But let's give a hypothetical. So, in this case, in an ordinary case, let's say you perceive someone to be an alcoholic. They've actually recovered, and you don't give them a promotion because you say you're an alcoholic and you will be unable to handle this work. But actually, in fact, they're recovered. They can sue under this statute.
I think that's right.
But in this case, where they actually never were alcoholics and you perceive them to be alcoholics and you take an action prohibited against the statute, you can't sue. And I don't understand why that would ever be the result.
That's the result because if you, again, look to 8107A, that actual or perceived language, which is where plaintiff's claim arises from, is about creating parity or ensuring that.
Or you could look at it as saying this is a class of people who are, it's not defining the class who can bring the action. It's saying if you're in this group that is an active alcoholic, let's call it, you can't sue.
Your Honor, if that were the case, that would mean that the actual or perceived language serves a different function for this one particular context than it does for any type of discrimination claim. And there's nothing in the legislative history or the text of the statute that shows that that was the intent of the City Council.
But it is different, right? I mean, this section on alcoholism is different, especially the perception part of it, right? Because let's say I'm discriminating, employer discriminating based on sexual orientation, and I perceive that you are this particular orientation. I don't like it. I discriminate against you. Here I perceive you to be an alcoholic. There's something different about that, right?
That's correct. And perhaps some may wish the City Council or the City Human Rights Law to provide a remedy in that regard. But the reach of the City Human Rights Law is still confined or defined by the language of the statute. And as it stands, and the Second Circuit agreed with us on this point, the plainest and most obvious interpretation of these provisions is that it permits an employer to, quote, take appropriate action against an employee it believes rightly or wrongly suffers from alcoholism but is neither recovered or recovering.
Let's assume that you're correct, that the most obvious interpretation is the one that you're promoting. But isn't it, under the rules, don't we have to see if there's any reasonable way at all that we can accept the plaintiff's interpretation? And if there is, don't we have to, under our rules of interpretation, under the under what the city council has repeatedly said every time they've amended the statute, that we are to interpret it as broadly as possible in favor of plaintiffs? Don't we have to take all that into consideration and look to whether there is a possible interpretation that would make sense, that would extend coverage to these plaintiffs? And if we do that, isn't there one?
Your Honor is correct that this court does have to consider a reasonably possible interpretation. But our position is that plaintiff's construction is not a reasonable one, at least not after you engage in fundamental principles of statutory construction. The broad construction provision in the City Human Rights Law, Section 8130, it still requires courts to to apply the canons of statutory construction. And when you do that, what plaintiffs have here is they're departing from the most obvious or plain meaning of the text and instead pressing a tortured reading of it where you really have to go out of your way to...
So, but is your point that Restoration Act requirement that similar provisions or comparably worded language in the text, in this case, refers to the definitional section, not what you call the conduct section? Is that why you get to where you're arguing?
I think that's a different point than the one I'm pressing now, but I do agree that the one-way ratchet rule under the Restoration Act, it only applies when you're interpreting comparably worded federal or state counterparts with similar wording. And here you don't have that because neither the ADA nor the State Human Rights Law contains this similarly worded provision confining the definition of who is disabled in this
But it has the
context.
other provision. It has language that is similar, if not identical, to the other provision.
Well, it does have
Isn't that the tension?
the state and federal, the State Human Rights Law and the ADA does recognize that you can bring a claim, like a regarded as claim or a claim based on a perception. It doesn't actually contain the actual or perceived language that the City Human Rights Law contains, which on the face of that language seems to make it clear that the City Council was intending to establish parity among these claims.
Thank you, counsel.
Thank you.
Counsel? Why didn't your client bring in Article 78?
Good afternoon, Your Honor.
Good afternoon.
I was not involved at the time an Article 78 proceeding could have been commenced, so I am not in a great position to answer that question. But I will state that although other options were before the plaintiffs at the time, we don't believe, and it's a very strongly plaintiff's position, that they're not required. And a discrimination claim, which we believe is entirely appropriate here, brings forth completely different damages.
Did they have an administrative mechanism, put aside the Article 78, did they have an internal administrative mechanism to challenge the diagnosis?
No, the problem was, once
They are required to exhaust administrative remedies.
they were required to, well, they could have made certain decisions along the way, which would have landed them in the medical division. Once they're in the medical division, they would have been told something like, you're going to do what the Counseling Services Unit told you to do, or you're going to be disciplined with up to 30 days
So there's no
suspension.
administrative mechanism whereby they can say, it's an incorrect diagnosis, I'm not an alcoholic?
No, Your Honor. At that point, they would have had to wait to be suspended or terminated and then take it up either as an Article 78 or what we're doing right now.
So would it be incorrect to read the city statute, Section 8102-16A, as allowing discrimination against alcoholics, drug abusers, or other substance abusers unless they are recovered?
Yes and no. So the definition is broad. The definition of disability is broad. And then the exception below it, which is paragraph C, is a narrow exception for those who are in fact alcoholics.
Why is it an exception as opposed to a clarification of the definition for this particular category? Substance abusers, that includes alcoholics, drug abusers, and so forth.
Well, the provision begins with "in the case of." And it has been our position from day one, and it still is, that "in the case of" means the actual occurrence of alcoholism, drug addiction, or some other substance abuse. So starting there, it is our position that the statute lays out that you have to actually have the occurrence in order for this exemption to apply. If you don't have a case of alcoholism, then you never get to the exemption, and there's nothing to worry about. You stick with your protection that you've always had as a member of the protected category of disability.
The statute is about classes of potential victims, let's put it that way, right? So it's a classification. So isn't this provision, it's definitional. You concede, as I think you must, that the definitions apply throughout the statute, because that's what definitions are for, unless there's another provision that says the prior definition doesn't apply here. Definition applies throughout the statute.
That's correct,
So
Your Honor.
these definitions are about the class of victims that may proceed under the statute, because I'm not even clear why you have standing, but we'll put that aside for one moment. So isn't this a definition of the class of individuals that may bring an action? Then you worry about what is the nature of the action, which is her point. Then the nature of the action is what's the wrong that the employer did to this group? But you first must start out with fitting the class
Right. Are they
of
protected?
potential plaintiffs, of claimants.
Exactly.
Correct.
Right. Are they protected?
Correct.
And we do have disability as a protection. Disability includes mental impairments, which thereafter includes alcoholism. So we have a protected category.
But alcoholism is defined a particular way, and you will concede the council was free to define it as such.
Correct, but we
Right.
don't
They
agree.
could have included many other types of discrimination, many other kinds of potential victims, but they didn't. Why don't we have to honor that, even in light of the Restoration Act? Because this is an explicit choice by the council.
Your Honor, if we look at the legislative history, which is somewhat tortured, but I think it does help us understand that the definition is one thing and an exemption is another. And here, there's a big difference between defining a category of disability based on conduct and defining an exemption from that protected
Well,
class based on conduct.
You're defining a group of claimants,
Correct.
and your clients don't fit, well, this is the argument, don't fit the group of claimants.
They are
Therefore,
not-
nothing else matters, because you're not covered by the statute.
I'm not sure that I quite follow what you're saying, but I will do my best, Your Honor.
Mm-hmm.
I apologize if I'm missing the mark. We have a perception claim, which does make this a little bit different.
So let's say somebody calls me a name, a pejorative name making reference to someone with a disability. Would I have a claim then, if everyone I worked with started referring to me that way?
Absolutely. You're perceived as being a member of the protected class. And that is the point of our
And the
perception.
logic of that, is there any limit to the logic of that, to that perception? I mean, there are other legal remedies. See, assuming the equity of your case, which I think it's an easy thing to do, in just basic fairness, I think it's an easy thing to do that. The problem is when there are alternative remedies, it's harder for us to get to the equitable solution. And that's what leads me back to what Judge DiFiore opened up with a question to you, is if you have these alternative remedies, you're asking us to really torture the law here in pursuit of equity, yet at the same time, there are other perfectly rational remedies to you.
There was one other remedy. You're right. And we brought several others,
Right,
some of which
right.
we've lost
Sure.
along the way. But we have left with the New York City human rights law, and we believe it's still an appropriate remedy. And if I may take a moment and go through the legislative history, it may help for me to express to you the point of how this particular situation is helpful to us and not harmful. So in 1977, the New York City Council included recovered alcoholics as a protected category. So right from then, 1970s, recovered alcoholics were the category. So it was based on recovery. Then in 1981, they removed that altogether. And instead, they expanded the definition of handicap. They expanded that definition to include mental impairments, which thereafter was defined as including alcoholism. Now, at the time they did that, they also included a clarification or an exemption, if you will, that The definition applies to those who are otherwise qualified to perform the functions of their job. So that otherwise qualified was added at the time they removed recovery from the definition. Then they added, in the case of alcoholism, the term otherwise qualified means recovering and free of abuse. That is how the in the case of alcoholism got thrown into the statute. It was actually part of the requirement that the plaintiff be otherwise qualified. Now, the interesting thing is, in 1981, perception wasn't even a claim. So if perception's not a claim, in the case of alcoholism necessarily meant when you actually have alcoholism, because there was no perception claim even existing. In 1991, though, they rehashed it a little bit more. And in 1991, they expanded the disability definition to be what it is currently in 18102.16a, and they added perceived protected status as an additional element or additional avenue for recovery. When they did that, though, I'm trying to keep it slow, they removed the otherwise qualified requirement. So they had put it in 1981, and they added, in the case of alcoholism, otherwise qualified means you're recovering. But in 1991, they removed the otherwise qualified item.
I think I can follow what you are suggesting, but aren't you still left with this definition? So that you have to be perceived as falling within the class, and the class is explicitly defined in a way that excludes your clients, excludes someone who is not an alcoholic.
Your Honor, respectfully.
You can see that it might be more difficult, right? I mean, the council might itself see that the problem is not with someone being misdiagnosed as an alcoholic, but with someone who is an alcoholic but is recovering, and the employer nevertheless is unwilling to recognize the efforts at recovery, which is what the council is trying to protect that class and trying to recognize that effort at recovery.
I understand, Your Honor. That is one avenue that the council sought to protect against. However, our clients were protected as being perceived alcoholics. There was no question at the trial. There was no question to the jury. Were they perceived as recovering alcoholics? Were they perceived as not?
No,
So-
let me just try one more time. I understand, but I think the point I'm trying to make that I haven't necessarily heard you address is that the statute doesn't include the class that you're referring to. It could be that the council could change its mind and include them, but it has not done so. It's defined this group in a particular way, and it doesn't include the class you're referring to.
Your Honor,
You're
respectfully.
correct, the ADA and the state law does, but the city human rights law does not.
It does. It does because in the case of alcoholism is an application provision. It's not a definitional provision. It says that it does not apply in the case of alcoholism unless they're in recovery. There is a big difference. And I will suggest, Your Honor, that there's at least one other place in the New York City human rights law that does the very same thing with age, which is odd. But in 81075E and 81075G, it describes unlawful practices with respect to real estate services, and it includes the litany of protected categories that we're all familiar with at this point: age, race, gender, disability, and so on. However, in the subset for 5G, it's another applicability provision. And in that one, it says, these protections do not apply to unemancipated persons under the age of 18. So, Judge Rivera, to your point, there's not a redefinition of age for that subset, but they did say, although age is a protected category, if you're an unemancipated person under the age of 18, this particular protection doesn't apply to you. And Your Honor, in the same way, we suggest that 8107.16a through c is the same thing. You are protected in the outset, but if you are in fact an alcoholic, it will not apply to you unless you're in recovery and free of abuse.
Thank you, Ms. Jocelyn.
Thank you, Your Honor.
Ms. Park?
Sure. Just a couple of brief points. First, on whether there were internal administrative mechanisms available to the plaintiffs, we submit that the opportunity to present their case before the medical board, which is comprised of physicians, who will then review the diagnosis and the treatment plan, that was indeed an internal administrative mechanism.
Consequences of that were pretty severe if they were not successful.
They had well, not so much that if they were not successful, but if they did not follow the medical board's recommendation. But I will note that one of the plaintiffs.
Well, that would mean that they weren't successful.
Well, Nardini, I will just note that Nardini, there was no consequence for going through that vehicle. And Nardini is one of the plaintiffs who actually did not even take that opportunity to go before the medical board. As for whether 8107, the provisions in 8107, the provisions that my adversary cites, whether that serves the same function as 8102.16c. I mean, I'll just note very brief, this is the first time I've heard this argument, but 8107 is not the definitions provision of the city human rights law. So of course, the provisions under, the subsections under that provision would not mean definitional terms. 8102 is the definition, it's titled definitions, and it explains when the terms will be applied throughout the statute, which is why it's an opposite, the references to those subsections. And finally, as for the legislative history, I'll just say very briefly, it was the 1991 amendments when the actual or perceived language was inserted into the statute. It was that same amendment that configured the statute to what we know today as 102.16c. And in that same amendment, in those same amendments, the City Council broadened the classes, protected classes under the statute, and could have easily, had it wished to, changed the definitional provision to allow for plaintiffs' claims, but it did not. And certainly, plaintiffs are free to, or anyone is free to bring these concerns back to the legislator or the city council and ask them to amend the statute based on these policy concerns. But as of now,
It does seem to me that there's at least some arguable merit to the position that when they started with all these amendments, and then they took something away, and then they added something, and then they added the perceived, that they may not have realized what the consequences of that would be.
I mean, not if you understand, if we take the presumption that the city council, in enacting or amending language or adding language, does it intentionally. And with that understanding, it would be a tortured reading of the statute to support plaintiffs' claims.
Thank you, Ms. Park.
Thank you.